So some years back, I have an acquaintance who is a state trooper, and we were talking about different subject matters, of course, and he had a real heart-to-heart with me, and it was really discerning to me because what he told me, it broke my heart. He said, "Now, Derek, I believe you to be a good man. I can tell that you're very passionate and that you have a good heart and that you mean well by what you're doing. But I'm going to tell you this, and I tell it to you as a friend. I perceive that what you were doing, what you were studying, what you were preaching, what you were talking about, to be worse than that of a drug addict." And I just kind of was poised and collected myself and was listening to him. And he said, "Let me just tell you, I've been in law enforcement for over 27 years. I've been in the court system, and I have watched men and women with the same ideology and views that you have go into a court, and most of them get sent to the mental insane asylum or a mental facility, and they're diagnosed by doctors who are licensed by the state as having some type of mental disorder. And for you, I would hope that you would take this as constructive criticism as a friend, not as an officer, but do something constructive with your life, do something productive instead of what you're doing currently." And it really broke my heart. One, because the man had been in law enforcement for 27 years and presumed and assumed that he knew the law. Two, that he had been subjected to the court system for so long that he believed that things are just a certain way because, well, that's the law and that's the way they are. The other thing that bothered me about his statement is the fact that he compared what I was doing to a form of ideology that is self-destructive in nature. And I want to tell you guys that are just getting into this and just starting to learn this information. One, you are on the right path, okay? Two, you will end up losing your friends and your family over this. Maybe just for today, maybe just for tomorrow, maybe forever. Just be cognizant when you start to go down this path. There are a lot of people who systematically have been ingrained with a certain thought process, okay? And if that's going to bother you or be a detriment in your life, don't go down this road. Fall back in line, pick up the bag of lies, and just move forward because it's easy. Now, in my life, anything that's easy has never been worth having, okay? Everything that I have in my life was earned through sweat, blood, tears, and hard equity, okay? And those are the things that we typically value. In my life, I've watched young adolescents get handed brand new cars. Within 3 to 6 months, they've either wrecked that car, they've destroyed that car, they've got Reese's Pieces peanut butter cups melted all over the dash. They just don't appreciate it because they didn't have to put any equity into it to receive it, right? So often when we get things freely given to us or it comes to us easy, we don't really respect it. We don't really harness the enjoyment of cherishing it and taking care of it, right? And it doesn't just apply to earthly possessions, it applies to relationships as well. So I just wanted to kind of give that information to you. If you're just getting on this journey, please don't be discouraged by people who fail to read, who aren't open-minded. I mean, some of these public officials I talk to, some of them are very acutely aware of what's transpiring. You see it in their eyes and they'll just smirk. You know, I've had lawyers run out of the courtroom and chase me down in the halls going, "I never learned any of this in law school, and it really is quite fascinating. Where are you learning this?" I'm reading books. I'm reading books that you didn't read in Yale or Harvard or Princeton. I'm reading intellectual, superior renderings from people who were highly learned in law, okay? And they understand sound doctrines and principles. They don't study law through statutes. Rather, they have equitable eyes and they perceive the law based upon right and wrong. Okay, and it's a completely different way of looking at things. And innately in our heart, because the law is written on our heart, we know the difference between right and wrong. We know when we've made a mistake. So often we can hear it in the adversary's opinions. They will say something like, I agree with you, but... Okay, and that but there, that rebuttal there, is them telling you that they don't agree with you. They have their own interpretation of how it should have been or could be. When somebody agrees with you, there is no but that precedes the statement of, I agree, we concur, I accept your evaluation, I acknowledge the information that you're providing. Okay, or they try and justify their actions. I agree, I was in the wrong, but, well, there is no justification. Wrong is wrong. That's all I needed you to say. When you say but, you're telling me that you're not going to correct your behavior because somehow in your mind, you're justifying your actions. Yeah, I took it. I know I shouldn't have done it. It was wrong, but no, there's no but. It's either right or it's wrong. It's black or it's white. There is no in between. If you want to play the in between game, go be an attorney. Muddy the waters with a bunch of legalese and scrupled up language used out of your black magic, black law dictionary book, casting spells upon people who are less than inclined to be intellectually sound. Okay. So I just wanted to give you that story. I have a lot of them interacting with public officials and agencies. I can't tell you how many times I've had deputy sheriffs and sheriffs come out of the courtroom with me and go, man, they didn't answer one of your questions, bud, and that really bothers me. But I have to do what they say. And I thought to myself, damn, we are so far down the shitter, I don't know if we can recover. But at the same time, it was nice to hear from these agents and agency saying, hey, you know what? I really was listening to what you were saying, and I've never been involved in a court case with somebody who's so articulate and able to ask the right questions or make a statement that nobody in the courtroom who is perceived to be learned in law can rebut or object to. And that is powerful. So learning this knowledge does affect other people, and it does help them to maybe think outside the box that they've been structurally put in mentally, okay? And that's through the public school system and education system. Some of the people that I teach and help, I've noticed the ones that retain the knowledge the quickest are so often high school dropouts or people that never went to college. It seems as though that the less educated they are, quote unquote, through the public school system, the more receptive they are to reality. And so you may find that if you dropped out of school, you're far more inclined to receive this information than, say, one of your buddies who went to college and says, hey, look, you're absolutely batshit crazy. I went to college. I have a certain intellect and knowledge that I have gained through the system, and I'm here to tell you, you're not correct. But knowing that they can read and regurgitate the things they read and they believe what they've been told versus being able to objectively think on their own is what separates the men from the boys, okay? You're either somebody who can analyze information and put it to use, or you're just somebody who regurgitates what they've been told through CNN, NBC, ABC, MSNBC, and you're just one of those people who doesn't understand how to exercise critical thought process, all right? So let's get back to it. When we left off last, we were talking about nationality. Nationality, on the other hand, is not discretionary. Nationality is a product of the circumstances of your birth or the requirements for naturalization, which you in turn have no control over and cannot change. One can be a national of a country under Title 8 U.S.C. subsection 1101A21, have nationality, and call themselves a constitutional citizen and statutory national without being a statutory citizen because their political status is separate and distinct from their civil legal status. Yes, you can expatriate your constitutional citizenship and abandon your nationality. So giving up your nationality is therefore discretionary. Expatriation is a voluntary renunciation or abandonment of nationality and allegiance. Perkins versus ELG. Now, I would never, ever advocate that you expatriate, okay? And there's a number of reasons for it, and we're going to get into that. But there's a lot of people out there pushing, oh, just expatriate. I don't necessarily agree with their thought process here. Perkins versus ELG, 1939, 307 U.S. 325 59 S period CT period 884 83 L period ED period 1320. In order to be relieved of the duties of allegiance, consent of the sovereign is required. Mackenzie versus Hare. You know what's so funny about this word sovereign is it's so heavily frowned upon by the federal government, yet I seemingly find it in a plethora of U.S. Supreme Court cases. And nowhere in there, when they're talking about sovereign, are they making it a bad thing. But all of a sudden, the federal government comes along and says, you know what, we're gonna define a new term here. We're gonna compound two words together that mean completely opposite things, and we are going to give that a bad or negative connotation. It's much like the CIA did back in the early days when they coined the phrase conspiracy, and they made it out to be something bad. Well, when does a conspiracy become a fact? How much evidence does it take for you guys to realize that some of the things I speak of, although they are perceived by federal agencies, CIA, NSA, ATF, DEA, as conspiratorial, yet the surmounting weight of the evidence and the facts compounded together is conclusively undeniable. So when does that conspiracy become conspiracy fact, or just a fact in general by itself, without the negative connotation of the word conspiracy, as the CIA would have you believe being a bad thing? Okay? So all conspiracy means is that somebody is thinking outside the box, subjected to the facts that they were subjected to, saying there's got to be more to this. There's got to be something that is being left out. This seems to be a one-sided projection of the facts. And because of that, I have a notion or reason to believe that there may be other facts out there that would be able to better assess the situation. And that right there, that being a critical thinker makes you a conspiracy nut. Okay? Don't let that detract you from being a free thinker. Get outside that confinement, that box, that jail, that prison they put you in your mind, by having everybody else in society look down upon you for being a free thinker. For example, we wouldn't have a light bulb if Thomas Edison wasn't a free thinker. Now, Thomas Edison stole the light bulb from actually a melanated man. You don't really find that too often in the American history books within your school system. But I'm here to tell you right now, the first functional light bulb with a filament in it was given to us by a melanated man. And that melanated man got his ideas stolen by Thomas Edison. Nikola Tesla, another perfect example of a conspiracy theorist, but without his theories, without him being able to think freely outside the box and outside the confinement of all the other educational institutions, we wouldn't have such an advent in technology throughout the centuries had it not been for Nikola Tesla thinking outside the box. So I implore you and I encourage you, despite what your local friends, family, and relatives, or even the government may think about you, to think outside the box, all right? Sovereign is required. Mackenzie versus Hare, 1915, 239 U.S. 299 36 S period CT period 106 60 L period ED period 297. Congress has provided that the right of expatriation is a natural and inherent right of the people, and has further made, notice how they don't say of the persons, they say of the people, and has further made legislative declarations as to what acts shall amount to an exercise of such right. The enumerated methods set out in this chapter are expressly made the sole means of expatriation. Municipal civil law determines how citizenship may be acquired. The renunciation not being given as result of free and intelligent choice, but rather because of mental fear, intimidation, and coercion, they were held void and of no effect. Tamoya Kawatika versus United States 190 F period 2D period 506 1951. But acquiring nationality and unconstitutional citizen status for most of us is not discretionary in most cases because you have no control over where you were born or the citizenship of your parents at the time of your birth. 2, you have to be a national and constitutional citizen of some country on earth. Otherwise, you would be an alien in every country on earth, akin to a fugitive whose rights would be protected by no one. If you would like more information on who would be protected by no one. Constitutional citizenship is not a revocable privilege. Okay, remember, privileges and grants from the government are all things that can be taken away from you. Okay, if you accept those privileges, you also accept the burdens that come with them. All right. So, constitutional citizenship is not a revocable privilege, nor any of the Bill of Rights, contingent on having that status. The Bill of Rights is applicable to all and not merely constitutional citizens. A common misconception of what we call 14th Amendment conspiracy theorists is the idea that the 14th Amendment essentially made the Bill of Rights into a privilege that made everyone subject to the federal jurisdiction. Below are some authorities proving that this is simply not the case. Now, for me, I typically use Article 1 through Section 10 as the Bill of Rights. It's the original. The rest are all amendments, all right? And it calls into question, because of the literature that I've read, whether or not any of the amendments after the 10th were actually properly ratified. Whether they were or were not is really up to the reader, I guess. The fact of the matter is, after the Reconstruction Act of 1871, the Federal Reserve Banking Act of 1933, the construction of Washington, D.C., the burning of Virginia, when you start to look at the War of Northern Aggression, never being free from the British colonies, the War of 1812, you start looking at all these things. My views are a little different than what is in here. However, with that said, there's a lot of great material here to retain, and most of which come from dissenting opinions from Supreme Court justices back prior to 1933, which I really, really appreciate those. Again, the court was never bestowed with the authority to create law. So when they call these things case law, it's an egregious misconception. Or enunciation of what they really are. They're court case precedent, okay? It's not court case law, it's court case precedent, has been said. All privileges granted to citizens by Amendments 1 through 10 against infringement by federal government have not been absorbed by this amendment as privileges incident to citizenship of the United States, and by this clause protected against infringement by the states. Watkins versus Oaklawn Jockey Club, D.C. Arc, 1949, 86 F period SUPP period 1006, affirmed 183 F period 2D period 440. The principles to be deduced from the various cases is that the rights claimed by the plaintiff in error rest with the state governments and are not protected by the particular clauses of the amendments under discussion. Maxwell versus Dow, Utah, 1900, 20 S period CT period 448, 176 U.S. 581, 601, 44 L period ED period 597. Although it has been vigorously asserted that the rights specified in the amendments 1 to 8 are among the privileges and immunities protected by this clause, and although this view has been defended by many distinguished jurists, including several justices of the federal Supreme Court, that this court holds otherwise and asserts that it is the character of the right claimed, whether specified as above or not, that is controlling. State versus Fletch, 1918-105, A, 2392 VT 477. The best way to distinguish between a right and a revocable privilege is whether it can be taken away from you without your consent. The right found in Amendments 1 through 8 of the Federal Constitution are non-revocable and require your consent to give up. Therefore, they could not be privileges, and in fact, the above case says so. There are certainly court cases we have read that identify portions of the Bill of Rights as privileges. This is a misnomer meant to confuse that conveys nothing useful. Earlier court cases identify the Bill of Rights as articles rather than privileges. The provisions of the Bill of Rights, however, cannot be lost without your consent, and therefore are not franchises, and therefore public rights. They are not property of Congress or creations of Congress, which can be taken away without your express consent. In fact, these rights attach not to your civil status, whether citizen or otherwise, but rather to the land you stand upon. That is why the Constitution identifies itself as, and I quote, the law of the land. It is locality that is determinative of the application of the Constitution in such matters as judicial procedure and not the status of the people who live in it. Balzac versus Puerto Rico, 258, U.S. 298, 1922. Congress enjoys two species of legislative power, and each has its own nationals. It is clear that Congress, as a legislative body, exercises two species of legislative power, the one limited as to its objects, but extending all over the Union, the other an absolute exclusive legislative power over the District of Columbia, or District of Criminals. The preliminary inquiry in the case now before the court is by virtue of which of these authorities was the law in question passed. Cohens versus Virginia, 19 U.S. 264, 6 Wheat 265, 5 L period ED period 257. This case was had in 1821. The above discretion is a product of what is called the separation of powers doctrine that is the heart of the United States Constitution and which is thoroughly described in the document below. Based on the above and on the foregoing section, there are two mutually exclusive and independent types of nationals. The U.S. Supreme Court sternly warned Americans not to confuse the two political jurisdictions when it held the following. I take leave to say, which means he's in chambers, in camera. He's taking leave of the court to say, if the principle thus announced should ever receive the sanction of a majority of this court, a radical and mischievous change in our system of government will result. We will, in that event, pass from the era of constitutional liberty guarded and protected by a written constitution into an era of legislative absolutism. The idea prevails with some. Indeed, it has found expression in arguments at the bar that we have in this country substantially two national governments. One to be maintained under the Constitution with all of its restrictions, the other to be maintained by Congress outside the independently of that instrument by exercising such power of absolutism as other nations of the earth are accustomed to. It will be an evil day for American liberty if the theory of government outside the supreme law of the land finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principle of the Constitution. Downs versus Bidwell, 182 U.S. 244, 1901, Justice Harlan dissenting. Prior to the 14th Amendment, constitutional citizenship derived from was dependent upon being what the U.S. Supreme Court also called as a citizen of the states or state citizen. But with the exception of these and a few others restrictions, the entire... I got to read this in its entirety. I can't skip ahead because it will leave out the substance. Hold on. It would be the vainest show of learning to attempt to prove by citation of authority that up to the adoption of the recent amendments, the 13th and 14th Amendments, no claim or presence was set up that those rights depended on the federal government for their existence or protection beyond the very few express limitations which the federal Constitution imposed upon the states, such as the prohibition against ex post facto laws, bill of attainders, and laws impairing the obligation of contract. But, with the exception of these and a few other restrictions, the entire domain of the privileges and immunities of the citizens of the states, as above defined, lay within the constitutional and legislative powers of the states, and without that of the federal government was it the purpose of the 14th Amendment by the simple declaration that no state should make or enforce any laws which shall abridge the privileges and immunities of the citizens of the United States, to transfer the security and protection of all the civil rights which we have mentioned from the state to the federal government, and where it is declared that Congress shall have no power to enforce that article, was it intended to bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the state. We are convinced that no such result was intended by the Congress which proposed these amendments, nor by the legislator of the states, which ratified them. Having shown that the privileges and immunities relied on in the argument are those which belong to the citizens of the state as such, and that they are left to the state governments for security and protection, and not by articles placed under the special care of the federal government, we may hold ourselves excused from defining the privileges and immunities of the citizens of the United States, which no state can abridge, until some case involving those privileges may make it necessary to do so. Slaughterhouse Case 83 U.S. 16 Wall 36 21 L period ED period 394 1873 emphasis added. After the 14th Amendment, constitutional citizenship became the primary citizenship, and a person not domiciled in a constitutional state is a national but not a state citizen. The first of these questions is one of vast importance and lies at the very foundation of our government. The question is now settled by the 14th Amendment itself, that citizenship of the United States is the primary citizenship in this country, and that state citizenship is secondary and derivative depending upon citizenship of the United States and the citizen's place of residence. The states have not now, if they ever had, any power to restrict their citizenship to any class of persons. A citizen of the United States has a perfect constitutional right to do and to go and to reside in any state he chooses. And to claim citizenship therein. 83 U.S. 36 113, and an equality of rights with every other citizen, and the whole power of the nation is pledged to sustain him in that right. He is not bound to cringe to any superior, or to pray for any act of grace, as a means of enjoying all the rights and privileges enjoyed by the other citizens. And when the spirit of the lawless, mob violence, and sectional hate can be so completely repressed as to give full practical effect to this right, we shall be a happy nation, and a more prosperous one than we now are. Citizenship of the United States ought to be, and according to the Constitution, is a cert and a undoubted title to equal rights in any and every state in this Union, subject to such regulations as the legislator may rightfully prescribe. If a man be denied full equality before the law, he is denied one of the essential rights of citizenship as a citizen of the United States. Slaughterhouse Case 83 U.S. 36 1873. There are, then, under our Republican form of government, oh, I fucking love that, Republican form of government, not Democratic form of government, Republican form of government, two classes of citizens, one of the United States and one of the state. One class of citizenship may exist in a person without the other, as in the case of a resident of the District of Columbia, but both classes usually exist in the same person. Gardena versus Board of Registers, 160 Alabama, 155. Statutory citizenship, however, does not derive from citizenship under the Constitution of the State of the Union. Statutory citizenship equates with the status of being a national and citizen of the United States under Title 28, 3002, 15A, B, or C, the District of Criminals, District of Columbia, or its territories, at birth under Title 8, U.S.C. subsection 1401, or a citizen of the United States, Title 28, District of Columbia, okay, the territories. Remember, District of Columbia is not a state. There's not 51 stars on the fucking flag. It's not a state. It's a private for-profit corporation. And if you're going to be a volunteer to that, then you are subject to the civil statutory laws and the legislature and the Congress and everything else. Remember these things. Under Title 8, U.S.C. subsection 1101, A22A, the type of citizens spoken of in the United States Constitution are only biological people and not artificial creations such as corporations. Here is what the annotated 14th Amendment published by the Congressional Research Service has to say about this subject. Citizens of the United States within the meaning of this amendment must be natural and not artificial persons. A corporate body is not a citizen of the United States. 14 Insurance Co. versus New Orleans, 13 Fed, case 67, CCDLA, 1870. Not being citizens of the United States, corporations accordingly have been declared unable to claim the protections of that clause of the 14th Amendment which secure the privileges and immunities of citizens of the United States against abridgment or impairment by the law of the state. Of a state. Orient Inns Co. versus Daggs, 127 U.S. 557561. This case was had in 1869. This conclusion was in harmony with the earlier holding in Paul versus Virginia, 75 U.S. 8 Wall, 168, 1869, to the effect that corporations were not within the scope of the Privileges and Immunities Clause of state citizenship set out in Article 4, Section 2. See also Selivar, Bates and Co. versus Walsh, 226 U.S. 112, 126, 1912, and Barra College versus Kentucky, 211 U.S. 45, 1908. Liberty Warehouse Co. versus Tobacco Growers, 276 U.S. 71, 89, 1928. And Grosjean versus American Press Co., 297 U.S. 233, 244, 1936. Annotated 14th Amendment Congressional Research Service. 14th Amendment conspiracy theorists who deny that they are citizens of the United States, constitutionally protected, as described in 14th Amendment, indirectly are admitting that the only thing they can be or are is a corporate or artificial entity. Why? Because, number one, there are only two types of American citizens, statutory and constitutional. Two, the only one of the two types of citizens who is, in fact, expressly identified by the U.S. Supreme Court as a man or human being, and emphatically not an artificial entity or corporation, is a constitutional or 14th Amendment citizen of the United States, protected by the Constitution and the Union States constitutions as well. If you are born or naturalized here and deny being a constitutional citizen, the only other thing you can be is a statutory citizen. We talk about this common freedom fighter fallacy in more detail later on. It seems truly ironic that ignorant freedom lovers who don't read the law and who even want to avoid being associated with a corporation would do that to themselves, don't you think? Some people might try to escape this logic by saying that they are two types of constitutional citizens. Citizens of the United States protected by the Constitution as identified in the 14th Amendment, and the citizen of the original Constitution. However, the following case holds that the 14th Amendment citizen of the United States is a superset that includes everyone, including the white capital C male of the original Constitution, so this assertion is clearly flawed. By the language, citizen of the United States was meant all such citizens, and by any person was meant all persons within the jurisdiction of the state. No distinction is intimated on account of race or color. This court has no authority to interpolate a limitation that is neither expressed nor implied. Our duty is to execute the law, not to make it. The protection provided was not intended to be confined to those of any particular race or class, but to embrace equally all races, classes, and conditions of men. ID 128-129. The 14th Amendment, by the language, all persons born in the United States and subject to the jurisdiction thereof, was intended to bring all races without distinction of color within the rule which prior to that time pertained to the white race. United States versus Wong Kim Ark, 169 U.S. 649 18 S period CT period 456 42 L period ED period 890 1898. The U.S. Supreme Court also described what it meant by subject to the jurisdiction, and it means physically present somewhere within the country or what they call territory of the nation, rather than the statutory United States at the time of birth or naturalization. And when we get back, we will talk about that.